Committee will come to order. Good morning, colleagues. So good to see all of you. Only 6 members here today, not much interest in this measure, apparently. We're hearing today the Comprehensive Alcohol Regulatory Effectiveness Act, H.R. 5034, and we're delighted to have Gary Miller, Edolphus Towns, Pete Defazio, George Radanovich, Bruce Braley, and we'll start with Mike Thompson of the 1st District of California. Welcome to the judiciary.
Thank you, Mr. Chairman, Ranking Member Smith, and other members.
Turn on your mic.
Thank you, Mr. Chairman, Ranking Member Smith, and other members of the committee. I appreciate the opportunity to be here this morning to testify. I was here just a few months ago to testify before the Courts and Competition Subcommittee that the wholesalers' legislative proposal would do serious harm to thousands of American businesses that make beer, wine, and spirits. Since that bill was introduced, these businesses have been joined by more than 100 major organizations like the American Farm Bureau, the National Association of Manufacturers, the American Bar Association's Antitrust Section, and believe it or not, the Progressive Policy Institute and FreedomWorks, 2 groups that you rarely see on the same page. The NFL and Major League Baseball all joined in opposition to this bill because it would discriminate against producers and limit the choices for American consumers. Today we're back discussing a rewritten version of the same bill, which I can tell you without question is just as damaging as the original version. The bill is still opposed by beer, wine, spirits producers, and it has all those major organizations that represent them. It still allows states to discriminate against producers in ways that promote economic protectionism. It would still seriously harm American businesses and take choices away from American consumers. You'll hear today from legal scholars and industry experts who can tell you the broad negative implications of the bill, but I'm here to explain how if this bill were to be passed into law, it would hurt the lives and the livelihoods of people across our nation. I can tell you about the family-run winery that's only in business because of the following that they've been able to develop through online sales. The small vineyard that wouldn't be in business and that the ag land that it occupies would probably be lost if wineries couldn't sell directly to retailers and restaurants. The rural consumer who can't get her favorite spirit unless she can buy it online. The brewery that can't get to wholesalers to pay attention to their microbrew. But it's the business that they built through a nationwide cult following that allows them to stay in business. These are the people that this bill still hurts. Those entrepreneurs and farmers are scared that Congress is going to irreparably harm their business by passing this bill. Small businesses are struggling in every one of our districts. Times are equally tough for the wineries in my district, but they've all been able to reach out and find customers. Many of these wineries are small, with a very limited production, and they've had to be innovative because many wholesalers won't give them the time of day. This bill, if passed into law, would keep them from selling an American product to American consumers, and as a result, would threaten thousands of good jobs. Is this bill needed to solve a problem? No. Is the current system broken? No. State-based 3-tiered alcohol distribution systems are working extremely well. Are states being treated unfairly? No. A state's right to pass alcohol laws is fully protected by our Constitution. In fact, there are over 4,000 state alcohol laws on the books, and there's no evidence and no avalanche of litigation to suggest otherwise. Are wholesalers being treated unfairly? No. In California, our wineries can distribute to anyone, consumers, restaurants, even Costco, and our wholesalers are thriving. The top 2 wine and spirits wholesalers in California brought in over $10.5 billion in 2009. They're estimated to bring in $10.7 billion in 2010, a more than $200 million increase in the middle of the worst recession that we've ever seen. In the U.S. wine business, the top 10 wholesalers control over 60% of the market. Clearly, they're doing well. This bill is at best, Mr. Chairman, a solution looking for a problem. But if passed, it would be a huge problem for U.S. businesses and consumers. The Commerce Clause of our Constitution, from which the alcohol industry would be exempt were this bill to become law, was designed to ensure a fair national marketplace. A state can pass their own laws, they just can't discriminate against out-of-state producers, nor out-of-state products. Congress and the Supreme Court have upheld this principle. Why would Congress want to turn back these decisions and deprive family businesses of their constitutional right? Mr. Chairman and members, this bill is not needed, and it would unfairly discriminate against producers and retailers and limit the choices of consumers purely to give a competitive advantage to wholesalers. I urge you to oppose this bill, and I thank you again for your time.
Thanks, Mike Thompson. I now turn to Pete Defazio, Oregon.
Thank you, Mr. Chairman. Always good to see you. Just wish it wasn't for this issue today. You know, I appreciate the opportunity to speak here today. I actually have the honor of being the co-founder and co-chairman of the House Small Brewers Caucus, but my remarks could as well reflect the concerns of the more than 400 vintners in my state, and I am a member also of the Wine Caucus. There are over 1,600 small breweries in this country. The brewers working in them are true craftsmen, creating a uniquely American product. There are also small businessmen and women creating thousands of jobs in local communities across the country. They do all this in one of the most highly regulated business sectors. Small brewers are, for the most part, they're not rich men and women. They operate with small margins, higher costs than the large corporations, and they compete against those large corporations every day. Even small, minuscule changes in their client base, particularly in this economy, can have a massive impact on their abilities to survive. H.R. 5034, the CARE Act, is a direct threat to their success. The bill would demolish the constitutional balance and federal oversight over alcohol regulation. The effect would be devastating to America's small brewers. The CARE Act would virtually eliminate the role of federal courts in stopping states from enacting discriminatory laws, violating antitrust laws, and even undermining acts of Congress. There are dozens of cases stretching back decades where federal courts have relied on the Commerce Clause to strike down blatantly discriminatory state alcohol laws. One example, in New York, federal courts struck down a state law that required all beer to have its own unique UPC code. Now, that's not a problem for Miller or Bud or any of those other foreign-owned giant corporations, but it is a problem for small brewers who operate on small budgets and tight margins. And they would have had to spend thousands of dollars on new labels just to be required to sell in one state, which would mean someone would go under, or they wouldn't sell there, or they might not add employees, a really bad and perverse result. That was justifiably stuck down. If H.R. 5034 is enacted, this type of law can and will return. Even worse, states would have free rein to come up with new ways to discriminate against small brewers or vintners. They could pass laws giving all in-state brewers or vintners preferential treatment, tax breaks for using in-state ingredients. States would then retaliate against other states over unfair laws, and we could have a real mess on our hands. This bill is anti-consumer, special interest legislation of the worst sort, and it undermines the basic economic principles of our Constitution. Why do we need this? Well, some would have us believe there's a flood of litigation out there. There is not, and it would protect state interests. State interests are protected today. Small brewers in Oregon and elsewhere obtain licenses, register their brands, and file tax returns in every state in which they do business. There has been no flood of lawsuits contesting these legitimate state interests, and no need for this legislation. Mr. Chairman, I would ask that the committee not act on this legislation. I appreciate the opportunity to testify.
Thank you, Pete Defazio, and you're unusually brief this morning. We appreciate that. Bruce Braley, Iowa. Greetings.
Thank you, Mr. Chairman. It's a pleasure to be here, and I want to thank the ranking member also for allowing me the opportunity to testify today. I respect both of my colleagues who have already testified. I have a slightly different perspective that I wish to share with the committee, and I'm here in support of the CARE Act because congressional silence on the ability of a state's right to regulate alcohol is being misused in federal court system by private interest. The 2005 Supreme Court decision in Granholm versus Held struck down some state regulation of alcohol. These regulations are necessary to ensure that alcohol is used safely by adults and kept out of the hands of children. Since then, it may not be a flood to Mr. Defazio, but there have been at least 20 lawsuits challenging state regulations that put into jeopardy the current system and create a burden for states like mine, Iowa. Alcohol, as we all know, is a unique product in American history. Wine, beer, and spirits need to be regulated differently than toothpaste, soda, or other consumer goods. Unlike other products, regulations are needed to promote moderation as well as to abide by drinking age laws so that responsible adults can enjoy alcoholic beverages responsibly. People in Iowa may have very different opinions than those in other parts of the country about how alcohol should be consumed, sold, and supplied, and it's essential to maintain the authority each state has been granted to regulate as they see fit. The simple fact of the matter is that states such as mine are seeking to protect the public interest, have been under attack from private interests that are seeking to provide personal gain for themselves. Iowa and 26 other states have been sued, and the opponents of state-based regulation and the special interests that fund them have been quoted as saying they won't stop suing until there's no law left standing. The private interests filing these lawsuits are not members of our community, but they're out-of-state corporate interests who bear no responsibility to our safety, our cities, or our constituents. In addition to 18 other states, Iowa is a control state, which means that it manages the wholesaling of liquor as a state-run enterprise. Our regulator is a member of the National Alcoholic Beverage Control Association, which unanimously voted to endorse the CARE Act. My Attorney General, Tom Miller, also signed a letter asking for congressional action on this issue, citing the significant time and resources required by states from unprecedented legal challenges. There has been exponential growth in the wine, beer, and spirits industry over the past 30 years, not in spite of a system of local control, which has always sought to balance socially responsible business practices on all tiers with robust competition in the marketplace, but because of it. Iowa also has a vibrant craft beer, microdistillery, and native wine industry that I support wholeheartedly, and I'm pleased that this bill will do no harm to them and, in fact, protect their right to self-distribute. Volume caps have recently come under attack using the Dormant Commerce Clause as justification, and I believe that it's necessary to defend the right for these businesses and look forward to working with small businesses to help them thrive and grow. So, again, Mr. Chairman, I'd like to voice my support for the CARE Act and hope that you can find time to move this bill to the floor at your earliest opportunity, and I yield back.
Thank you so much. From Brooklyn, New York, Chair of the Committee on Oversight and Government Reform, Edolphus Towns. Welcome.
Thank you very much, Chairman Conyers and Ranking Member Smith and members of the Judiciary Committee. Thank you for the opportunity to express my support for H.R. 5034, the CARE Act. States need assistance in defending laws which protect the public interest from those who are seeking to line their pockets by deregulating the alcohol industry. My home state, New York, has been sued not once, but twice in the past 4 years. Attorney General Cuomo and 38 other attorneys generals wrote to me in the spring seeking congressional action to assist them in stemming the tide of these lawsuits, and I am proud to help. On a more personal level, I believe that our constituents know better than anyone the terms of how they want alcohol to be sold and supplied in their community. Alcohol is different than any other consumer good and should be regulated as such. And our constituents know this and want the ability to control this product to protect public health and the public interest. Here are two examples of how this bill will help to protect our communities. First, laws that mandate identification checks have recently come under attack in court by online liquor stores who view them as discriminatory. I believe that ID laws assist retailers and communities to keep alcohol away from minors and are vital components in protecting public health and safety. Second, New York City and communities across the country have begun using alcohol control zones to stop the practice of single sales and the sales of certain products such as malt liquor. These products are not conducive to public health or public safety. These control zones have made my community safer, and law enforcement has testified to this result. I fear that without congressional action, these laws will be challenged as well, erasing a great deal of progress that we have made. I will leave you with one last thought. To gauge how I'm doing back in Brooklyn, I use what we call the church test. This basically involves me speaking directly to my constituents outside the houses of worship. As I conduct this test, I regularly hear the need for better schools, a better economy, more police presence, and a better healthcare system. What I do not hear from any of them is about the need for cheaper, more accessible alcohol. And that will be the end result if we fail to act on this legislation. I want to thank you, Mr. Chairman, and for the opportunity to come and to indicate my support. And on that note, I yield back the balance of my time.
Thank you, Edolphus. Which side would we be on to get cheaper and more available alcohol? Would you clarify that for some of the members up here?
My side, Mr. Chairman, I would be against cheaper. I mean, I think that it's fine as it is.
Well, you just slid into invisible minority there, buddy. Too bad, Brother Towns. George Radanovich, 19th District, California. Welcome and good morning.
Thank you, Chairman Conyers, and thank you, Ranking Member Smith and members of the committee. Appreciate being able here to testify. As co-founder of the Congressional Wine Caucus and member of the Energy and Commerce Committee, which has jurisdiction over interstate commerce, I'm also have been an owner of a California winery. The business of wine is far from the splendor of the vineyards. It's difficult to sell wine, maybe more difficult than selling most other products or services in the United States, and much of that is due to the level and the diversity of regulation and control of all aspects of the business. Wine is a highly taxed and highly regulated business with 50 sets of laws as well as oversight from numerous federal agencies. In such an environment, there are great costs involved not only in making wine but also in getting wine to the market. Tax rates differ. Some states require licenses or permits, and still others require that I pay a fee to register my labels. One state required that I buy a license and hire a wholesaler to distribute my wine, and then I designate a sales territory for that wholesaler, while a second state prohibits me from doing this very same thing. One state makes it virtually impossible for me to fire my assigned wholesaler, even if the wholesaler is not performed as represented. In most of the states we tried to ship into, every bottle of wine had to pass through a wholesaler, which added costs and delay, and even though the wholesaler was doing little, if anything, to help build the brand. For new wineries, it's always a shock to realize how difficult it is to acquire distribution in other states. Even for long-established wineries, significant resources are required to comply with varying state laws. In many cases, compliance with certain state laws discourage my winery from selling in those states. This is common among thousands of wineries. The cost to introduce a wine in a market can far outweigh the potential profits. People in the wine business hear a lot about the three-tiered distribution, but all know that a pure three-tier distribution system does not exist in the United States. Instead, over the years, since Prohibition was repealed, states have chosen to exercise their powers under the 21st Amendment to create hybrid distribution systems that use three-tier principles as a framework. In at least 39 states, state laws allow in-state wineries to self-distribute. Self-distribution laws permit the in-state winery to act as its own distributor. allowing direct sales by the winery. In California, the number of wineries could not increase without self-distribution, but self-distribution stops at the state line. In my home state, I'm allowed to sell wine directly to a consumer. I can operate a wine tasting room at the winery and one other retail location where I can also conduct educational wine tastings. Without this manner of distribution, most small wineries would find it difficult to survive. Many wineries are surviving in today's economy solely on the strength of their direct-to-consumer wine clubs. I remember a time when some states would punish such sales as felonies. Operating a winery in this country is difficult and complex. The wine industry is an industry of different laws and confusing regulations, which is why I wholeheartedly disagree with the premise of H.R. 5034 that states' rights are being greatly impaired by the Commerce Clause, that states should be able to regulate alcohol products even if it means that they can openly discriminate, and that states are on the verge of regulatory collapse without congressional intervention. In my 16 years of Congress, I do not recall another time when an industry group has come seeking complete immunity from nothing less than the U.S. Constitution. I am interested to hear why today's speakers think the only way to prevent such deregulation is to surgically remove that portion of the Constitution from applying to their industry. I wait for an explanation as to how this assault on the Constitution will better serve the industry, the states, the nation, and the American consumers. H.R. 5034 is being promoted by the beer, wine, and spirits wholesalers. They present this committee with a simple request. They want Congress to expressively give states the ability to regulate alcohol without limits of national fairness and market equity. They say that without this express permission from Congress, states will be unable to regulate effectively. As a member of the Energy and Commerce Committee, I urge this committee to listen carefully and respectfully to today's testimony. If we allow states to set their own alcohol laws and market ends at the state level, we lose the cohesiveness and energy of our national market. By allowing trade barriers that openly defy these concepts of an American market, we become 50 nations instead of one. Small businesses like my winery will see themselves shut out, and it will become harder and harder to make a profit and provide jobs. Again, I want to thank the committee for giving me this opportunity to testify on this important legislation, and I ask that my full written testimony be submitted to the record. I would also like to submit for the record a recently released analysis by the Freedom Works Foundation, along with a resolution that recently passed the California legislature opposing this bill.
Without objection, so ordered, and thank you, George Radanovich. And now we turn to Gary Miller of California. Welcome, sir.
To defend the chairman, I am not against lower prices for legal consumers nor members of Congress. We're on the same side here. Mr. Chairman, Ranking Member Smith, thank you for the opportunity to testify before you today about the impact of H.R. 5034, the CARE Act. While the issue of alcohol regulation is complex, I would like to focus my testimony on the impact of this proposed legislation on underage drinking. According to the National Alliance to Prevent Underage Drinking, every day 7,000 children under the age of 16 take their first alcoholic drink. Youth who start drinking before the age 15 are 5 times more likely to develop alcohol dependency or abuse later in life than those who begin drinking at or after the age of 21 years. And according to the Center for Disease Control, although drinking by persons under the age of 21 is illegal, people aged 12 through 20 years drink 11% of all alcohol consumed in the United States. With a nearly $170 billion annual market for alcoholic beverages, underage drinking comprises a significant part of this market. One of the most important ways we can limit underage drinking is by reducing illegal access and increasing enforcement. We must require a strong regulatory structure that balances the free market with public health concerns with respect to alcohol. The system of state-based regulation has served our nation well because states and localities know their own communities' needs best. A one-size-fits-all strategy does not work with alcohol. What is socially acceptable in one part of my congressional district, much less the country, won't work in another. All alcohol regulation is a balance between competition, price, and availability on the one hand, and appropriate control to mitigate moderate and underage consumption on the other. Each state must determine how this balance should be achieved and where the appropriate balance point should be fixed. States view alcohol differently from the authority of each state to regulate according to its own norms and standards must be safeguarded. Surely it is not in the public interest to advocate for weak regulation in an unrestricted marketplace. While I understand that some of our nation's small businesses rely on the internet to widen their marketplace, we must ensure that appropriate precautions and regulations are followed so that the enforcement of state underage drinking laws can be adequately enforced. No one will argue that it is not the state's responsibility to monitor alcohol sales and consumption by instituting and enforcing age restrictions. Indeed, minors on the internet can purchase wine, beer, or grain alcohol with a click of a mouse and have it delivered to their house. Sting after sting by law enforcement and media consumer protection advocates have shown just how easy it is for minors to buy alcohol online with no ID check or age verification. Many online businesses rely on interstate carriers to verify the legality of an alcohol shipment. It is commonplace for the buyer to self-certify that they are of age. It is up to the individual UPS or FedEx employee delivering the shipment to verify the age of the recipient. The problem is that the Supreme Court has ruled that the states cannot require interstate carriers to verify the recipient's age. This, of course, raises questions as to whether legal liability would lie if indeed a carrier delivered alcohol to a minor without first verifying age. Many of the legal decisions rendered in the Granholm have been conflicting, leaving regulators, attorney generals, and legislatures in a dilemma with regards to their authority to regulate the unique product. We need to clarify congressional intent that the states are the primary authority to regulate alcohol sales and that they should exercise the authority to protect the public interest. In a narrow, balanced fashion, revised version of H.R. 5034 accomplishes these goals. H.R. 5034 keeps in place the state's authority to regulate alcohol, but upholds the high standard of the Granholm decision to ensure interstate commerce. The character expressly prohibits a state from enacting discriminatory laws that favor in-state producers of alcohol to the detriment of out-of-state producers. In fact, the bill reserves the right of states to enact strict regulations, and such regulations advance a legitimate local purpose. Ensuring that minors do not have inappropriate access to alcohol is an example of such a purpose. In the end, the bill would force retailers to be responsible not only to their bottom line, but to the communities they serve as well. While the confusion in the court system spurred by the Granholm decision creates regulatory inconsistencies based on judicial jurisdictions, this alone makes it necessary for Congress to clarify intent. However, according to the Concerned Women for America, the authority for states to manage the distribution and sale of alcohol is especially critical for society to effectively regulate access to alcohol to minors. As a conservative, I'm regulating on the side of lessening the regulatory burden on our businesses across America, but I will not endorse a strategy that weakens state law and helps underage access to alcohol.
Thank you very much. Did any of you hear any of your colleagues say something that you felt like you'd like to make a comment on? Mike Thompson?
Thank you, Mr. Chairman. I don't want to, I could go on and on disputing some of the things that have been said, but a couple of folks have referenced state attorneys general positions on this bill, and I think it's important for the record, if you would allow, to take these 10 letters from 10 different state attorney generals who are stating that, in fact, their support for this bill was misrepresented. They have no position on that. I'd like to submit that. And I'd also like to submit for the record the American Bar Association's antitrust section opposition and the Progressive Policy Institute's position of opposition as well.
We'll accept them into the record.
Thank you, Mr. Chairman.
Anyone else feel disposed to make any comment before I excuse and thank all of you for your statements? Okay, thanks so much. Let me start the hearing by calling this the last hearing of Bill Delahunt, so that we'll have this dedicated appropriately. And this is also his bill, so I just want to take this moment to thank Bill Delahunt for his many years of service, not only on this committee, but as a prosecutor in Massachusetts, and all the friends that he's garnered on both sides of the aisle. And I think I'll put the rest of my statement in the record and yield to my dear friend, Mr. Smith.
Thank you, Mr. Chairman. I certainly agree with you and want to thank our colleague Bill Delahunt for his years of service to his constituents and to his state and to our country, as well as his dedication to this particular committee. Bill Delahunt is one of the most able, most effective members of Congress who I know, and he and I have worked on a number of pieces of legislation together showing that bipartisanship can work, and particularly with someone like Bill Delahunt, who is well motivated in so many areas. And we wish him well, and I have a hunch that we will be able to stay in touch with him and keep up with him and look forward to hearing from him as we go into the next Congress. Even though he may not be present, we will certainly remember all of his contributions and continue to appreciate him and his service, and I do hope he stays in touch with all of us.
You bet. Howard Coble.
Mr. Chairman, I know time is important. I'll be very brief, but my fellow Coast Guardsmen, I'd be remiss if I didn't echo what you and the gentleman from Texas just said. I'll put me on your line.
All right. Bill Delahunt, Hello, and
It's nice. It's nice to be present when you're hearing your own obituary. People tend to say very positive things when you're leaving. Just a quick anecdote, Mr. Chairman. During the course of the primary, I was asked to endorse a particular candidate to succeed me, and I said I'm not going to get involved. And this particular candidate said, well, it's absolutely essential. And I said, why is it essential? He said, because your numbers are through the roof. And my response was, they're through the roof because I'm leaving. Let me just say this. It has been an honor to serve on this committee. This committee has a tremendous record. I think oftentimes the public is unaware that despite the policy disagreements that are obvious on a number of issues, that the personal relationships are such that it has allowed this committee to perform admirably. I consider every member of this committee a friend. And those friendships with you, with Lamar, with Howard, Coble, and with every member, I will truly cherish. And those friendships will endure long after the campaigns are over. You know, political life is difficult. I don't think the American people really understand the sacrifices that members make. I can say that now because I'm leaving. But each and every member of Congress, each and every member of this committee work diligently. They work because they're here to serve. We have a different understanding sometimes in terms of what's the best for public policy. But people here are committed. They're committed to their country. They're committed to their district. And they make tremendous sacrifices. This is a job that never ends. When we leave here, we go back to our district and communicate with our constituents. But every member of this committee can be very proud of what we've accomplished, at least during my 14 years, and I dare say as we look forward. But let me just end by saying the friendship, your friendship, Lamar Smith friendship, and everyone's friendship is a memory that I will take with me and enjoy and savor and cherish for the rest of my life. You said, Mr. Chairman, this is the last bill in the last hearing. I want you to understand that I drafted or authored this bill because I believe it is an issue that demands immediate attention to prevent the, in my judgment, the unraveling of America's system of alcohol regulation. It's important to it has an important goal. It's a very simple one, and that's to protect communities, protect children, and protect families. My granddaughter was with me this morning when we took the Pledge of Allegiance to the flag on the floor of Congress. I want to make sure that she is protected in so many different ways. I've witnessed, as a former prosecutor, the ravages of alcoholism and alcohol abuse and what that can do and what that can lead to. And that's why I sponsored this legislation. I want that to be known to my constituents back in the Massachusetts 10th District, and I have a more lengthy statement that I'll submit for the record. Thank you, Mr. Chairman.
Thanks, Bill Delahunt. I want you to know that the picture we have of you in the hallway it's going to remain up even after you're gone. So that's about the highest tribute that we can offer anybody in this committee.
Thank you, Mr. Chairman.
You're welcome. Lamar Smith.
Thank you, Mr. Chairman. As you have noted, our judiciary colleague, Mr. Delahunt, introduced H.R. 5034, the Comprehensive Alcohol Regulatory Effectiveness Act of 2010, on April 15th. Since that time, the bill has acquired 146 co-sponsors, which represents a remarkable level of bipartisan support. However, it has also generated a great deal of controversy among wineries, breweries, and distilleries. They believe that the bill, as introduced, could lead to discriminatory state regulation and legislation that could hurt some small businesses. Most states have enacted some form of the three-tiered system for alcohol distribution. This system separates alcohol producers, alcohol wholesalers, and alcohol retailers into three distinct tiers. The inclusion of wholesalers as middlemen in the transaction makes it easier for states to regulate alcohol. It makes it possible for states to ensure that alcohol is safe. It makes it simpler to ensure that alcohol is sold only to individuals over 21 years old. And it provides a straightforward alcohol tax collection system for states. These are all laudable goals, and for those reasons I support the three-tiered system. And I feel it is important to help the states maintain and defend this system and the benefits it brings. At the hearing in March, we were told that the three-tiered system was under assault by lawsuits from producers and retailers. It was claimed that these suits are a drain on states' finances and diminish their ability to effectively maintain the safety of the alcohol distribution system. The CARE Act was designed to limit these lawsuits. However, as I've told many of the wineries in my home state, I also recognize that the legislation perhaps went too far to achieve those laudable goals. And I am pleased that Mr. Delahunt has offered and is preparing a manager's amendment that I think addresses many of the producers' complaints about the original language. I appreciate his efforts and those of the chairman to create an improved piece of legislation. I am also well aware that the producers, as well as some retailers, still oppose this modified proposal. To that end, I would like to use this hearing to get at the facts of the matter. First, how many lawsuits are there? How does the number of lawsuits compare with the historical average? How much do these lawsuits cost states? What other priorities do the states have to forego to defend these suits? The revised bill provides that states cannot discriminate against out-of-state producers. Are there examples of states discriminating against out-of-state commerce? Are there any examples of statutes that have been overturned even when there was no evidence of intent to discriminate? What additional specific suggestions can those who oppose this bill make that will enable us to address their concerns without hampering this effort to preserve the three-tiered system that has served us so well? These are some of the questions I hope our panel of witnesses can help us answer, and I hope these answers will help us construct a bill that will be acceptable to all stakeholders. With that, Mr. Chairman, I'll yield back the balance of my time.
Thank you. We'll take a couple more opening statements when we return, but right now we'll recess until 12:30 in the afternoon. Thank you.
Well, the idea was go to the floor, take the votes. We're going to take the first part of the bill on the floor. So we estimate 12:30 will be done.
Okay, 12. He's saying he's estimating about 12.
So it'll be right after judiciary.
Yeah, because they got to do votes and then they got to do the bill.
Do me a favor on this, Stuart. I just so you see that, but also pass that on to whoever might in the future might be reviewing statements or whatever.
Okay.
I have your 9/11 statements with the
Yes.
edits. Do you want me to hang on to them?
Yeah.
Okay, I'll see you down on the floor.
Okay.